Okay, Grover Norquist here with Americans for Tax Reform, the Leave Us Alone program. And we're going to be talking about one of the few things the United States does more stupidly than all other countries. Usually when we compare the United States to other countries, we're doing it right, they're doing it wrong. Tort law, suing people over damages, and efforts at tort reform does not fall into the category of where we do it best here in the United States. I have with us Tiger Joyce, who is the president of the American Tort Reform Association. So he's trying to fix stupid, okay? Just to make sure we're not having an argument here, we're on the same team. We're going to be discussing the damages of how tort law is handled in the United States and compared to other countries. Tiger, could you walk through this? How did you get to run the group that fights against all the trial lawyers? You got out of college and signed up, or did you bounce around, do a few things first?
Yeah, well, thanks, Grover. Thanks for having me. Let me join you here today. My history is prior to coming to ATRA, which was now quite some time ago. Let's just say I was a young man at the time, no longer. But I was counsel to the Republicans on the Senate Commerce Committee, and the issue we were dealing with then on a national basis was the effort to create a federal product liability law. So sort of a narrow focus about underlying liability law. I am a lawyer myself, although not in practice, obviously. And but that got me an entree into the whole sort of reform effort. And when this position opened up about the time I was looking to leave the Senate, that the opportunity presented itself, and I've been working on this, and our focus is predominantly on state law issues, legislative reforms and state court cases.
Okay. Could you explain to people what tort law is? It's not Perry Mason, go to jail, go to the gas chamber. What is tort law, and how much of it's national, how much of it's state, and is any of it local?
Yeah, well, that's a great question. Tort law, if you sort of draw the major points of distinction, obviously, a lot of attention recently on criminal law cases, and those are, cases where individuals violating statutes and the government, whether it's the U.S. government or or a particular state, is bringing charges against an individual on behalf of society. Civil cases are about money, and we're in the civil litigation area. And probably the easiest point of distinction would be to contrast it with contract law. Contracts are about agreements. You enter into a deal to do something, to buy something, or to undertake something, and that's dealt with sort of more broadly in that area. Tort law deals with, let's just say, non-contractual issues. Might be an auto accident. It could be something as complicated as an assertion that that a product was defectively designed. So it's just, if you think about it in those terms, it's matters that don't where there wasn't a pre-existing agreement active agreement between the two parties.
One can imagine how this ends up being abused. With a contract, two people got together and they decided on something, and then either later on they kept their word or they didn't, or you could theoretically have a disagreement about what the words meant, but the lawyers looked at it first. So most of that should be taken away when people avoid the problems because people both signed a contract.
Yeah.
There wasn't a contract necessarily.
Right. I just think for sort of a broader understanding of sort of the distinctions, that's just a good way to think about it. It's just that Those two sort of major areas, obviously, can be gray areas in between.
Well, could you give a couple of examples when somebody spills McDonald's coffee in their lap, and then they sue McDonald's because why? But somehow they get, at least the headlines tell us, they got $10 million. What are some examples of things that when people hear about, that's what tort law or the effort to reform tort law is about?
Yeah, well, there are a lot of different ways that it does manifest itself. The McDonald's case is now quite some time ago, and to be perfectly honest, Well, it got a lot of attention at that time. I don't think it would get much today, but what was interesting about that case was the a portion of the damages that were awarded. I think it was just under if I recall correctly, just under $3 million. But a significant portion of that got into an area that we continue to be very focused on, is what we call punitive damages. So within these economic awards, within the amounts that are given out or awarded in a judgment, there are different kinds. What are your actual out-of-pocket losses? Those are generally pretty easy to quantify, although obviously there can be a lot of dispute about what the actual amounts are. And then you get something that's much more inherently subjective, which we call non-economic damages, typically something like pain and suffering. If you've suffered an injury and you've had significant discomfort, or you might have sort of a persistent problem, aches and pains, or the worst, you can be compensated for those, but it's inherently subjective. But what was interesting about the McDonald's case was a third classification, which is called punitive damages, which are not meant to compensate. They are meant, as the name suggests, to punish. And the idea there was to exert, in effect, something akin to a criminal type fine in the civil case. And that makes it somewhat controversial. And in the McDonald's case, the jury decided there that they were going to award the lady who brought the case an amount equal to, I think at the time it was 2 days worth of coffee sales for McDonald's. That was how they quantified that punishment. And so gets into, again, a very controversial area. And actually, in the intervening time, the U.S. Supreme Court has actually established kind of a rough outer limit on how much, in the criminal law, a jury or a judge can't decide punishment beyond what the law permits. And so the Supreme Court has sort of established at least kind of a hazy line beyond which courts can't award for punitive damages.
When we talk about the United States having tort law that is more expensive, more clumsy, raises the cost of goods and services for people, because if McDonald's gets sued and has to pay millions of dollars to somebody who spilled coffee on themselves, the cost of coffee to everybody else in the country goes up, because McDonald's can't print money like the federal government. They only earn it by selling things. So that cost that the lady walks away go, oh, wow, McDonald's gave me this money. No, other consumers at McDonald's, the people sitting on either side of her when she bought her coffee, they're paying for what she got from McDonald's. How much is tort law, suing people for damages and for being hurt or for pain and suffering or for punishing, different in the United States versus other countries? Are there other countries like the United States? Are we completely sui generis? Are we completely unique in how we handle it? Or are we on a continuum somewhere in the middle between doing it wisely and poorly?
Well, a couple points I would say. Number one, I think we do have some data, which I think is helpful. And you made, I think, the most important point, Rover, which is that these matters, these cases, and the system doesn't exist in a vacuum. There's just not some sort of hypothetical fund that underwrites our legal system. It comes from all of us, and the excesses are a burden on all of us. We would call it the tort tax. In fact, we're familiar with an analysis that, looking at the nation as a whole, a typical family of four pays what we call the tort tax of nearly $4,000. So that's not an insignificant amount. The total costs in direct costs to implement the system is over $340 billion, according to an analysis by the Pyramid Group. So per year, yes. Those are the
$340 billion every year.
Yeah,
that's a good chunk of the defense budget.
Yeah, that's the direct cost, and the impact that they've estimated on annual output on GDP is over $500 billion. So it's sort of a cumulative cost, which impacts the economy. It's not an academic matter. It does impact. But as far as the rest of the world, probably the greatest distinction that we have, which some could argue, I mean, I think on one level serves a useful purpose if you're looking to always provide opportunities for people to have their proverbial day in court, is the contingency fee arrangement. And that is that people can take a case, can go to a lawyer, and the lawyer can tell that person, well, you're not going to pay me unless I prevail or unless you prevail in the matter, which, has a surface appeal. And for a lot of people, lawyers can be expensive. So there can be a sort of a basic justice in that. I think that what we've seen, obviously, over recent times is that we've gone well beyond that, where it's just serving the broader interest of potential clients and really lawyers really driving the litigation and litigation becoming the business itself and the lawyers themselves really being the central player. And we could sort of delve into that in more detail, but just that's, I think, the major distinction that we have.
Why, if somebody sues McDonald's because McDonald's coffee was hot and they spilled it on themselves, does the person is paid for any damage that they did to themselves by having hot coffee spilled on them, any pain and suffering, any actual doctor's bills? The punitive damages, why would the punitive damages, even if you felt that lawsuits are the way to do this instead of criminal laws, why would that money go to the defendant and to the lawyer who brought it rather than to the state? And when you pay a fine because of, you commit a crime, you pay a fine, or you could go to jail. If you paid a fine, it goes to the government. It doesn't go to the lawyers.
Yeah, it's a good question. And there have been proposals to shift that. I think that some of the lawyers that we talk to would suggest that if you think that punitive damages are a problem as they exist now, with the money going, the fees going, or the damages going to the individual, the thought of some pretty thoughtful lawyers is that those amounts would be even higher if they weren't viewed as a windfall for an individual. So that's, and there's a part from our perspective also from an efficiency standpoint. If the government had a stake in more and more litigation, then they would look to intervene potentially. So there's a very basic, you put your finger on a very important point, and it's understandable. But I think that kind of as applied, there might be some concerns about how that would play out.
Okay. Thank you. It seemed like, well, that would solve it, right? I read somewhere that Nebraska said that sort of stuff goes to the school system, and that then the lawyers quit asking for the money because they didn't get a third of that. If the punitive damages if they don't get a third of the punitive damages, would they ask for punitive damages in the first place?
Yeah, and punitive damages often can be, because of the sort of lack of predictability in many instances, are a lever for the for a plaintiff, and that's why they're routinely sought, or at least that they generally have been in the past. So a lot goes into how that potentially plays out.
What percent of GDP is swallowed up by lawyers and tort law?
Yeah, it's a good question. I don't know I have the precise figure, but I think that, when we look at that sort of that overall cost, we're looking at, well over $340 billion. And you're much more astute in the data and details on our economy, but it's at least a few percentage points of the world's largest economy. And
the last number I saw was 2%, which is also the number I remember from 30 years ago. So that seems to have been.
I suspect it's probably about that. I wouldn't think these days that it's declining. So there have been efforts at the state level to reform tort law, to make it not easy for somebody to basically threaten a company. I'll sue you for $1 billion
but maybe you pay me $5,000, I go away. And so people get paid $5,000 to go away, a lot, maybe more than 5,000. So you can shake down the city, or businesses or individuals. There were efforts in the past to reform that. Whole states passed laws, and then the courts came in and struck down those laws. Courts, Supreme Courts, often staffed with people who were chosen by the trial bar, by the other lawyers. So the lawyers choose who the judges are likely to be, and therefore they decide, no, we don't like, you can't write laws that get in the way of our friends making money. How much is that a problem? What is the path that you see to having it cost 1% of GDP rather than 2%, having it cost only $2,000 for a family of four, not four? How about, I mean, we don't want to go crazy and bring it down to zero. But what do you see? Does it take votes in state legislators? Do we have to get different courts? Can the federal Supreme Court, it's now changed it's different in many ways on many issues than it was 5 years ago. Is that something that could reform the cost of tort law, or is it all completely, mostly state?
Well, it's predominantly state law, I think, that we're talking about. And I think that, I'm not the great tea leaf reader as far as our current Supreme Court, or not U.S. Supreme Court. But I don't know that we're going to see the U.S. Supreme Court jumping into a lot of these matters per se. I think what has to happen, at least from our perspective, I would give you a good example, is in Florida. Governor DeSantis appointed some outstanding members of now the Florida Supreme Court. Yeah. And in 2023, this time last year, he signed into law a significant package of legislative reforms. And I think that combination is really provides a blueprint for what we think should happen, which is
better judges that aren't actually trial lawyers in disguise, and then laws which make sense, which aren't struck down by trial lawyers wearing robes.
Yeah, I think some of the cases of state Supreme Court striking down some of those the reform statutes happened in, I think one was in Illinois, one was in Ohio, and we haven't seen the volume of that in the sort of comprehensive way that we did a few years back in more recent times. But what we have seen are efforts, and proposals in courts, and sometimes state Supreme Courts, appellate courts, expanding liability, really in some instances kind of acting a little bit more like a legislature. A good example that, when we see the use of public nuisance, public nuisance used to be matters like, my neighbor has installed a factory or something, and I can't access my road, getting in and out of my driveway, matters of sort of routine like that, or they're, if they haven't properly kept up their put something in that's dangerous. But we're seeing public nuisances being used quite frequently as a legal basis to bring cases against, for example, the energy industry over climate change, the opioids litigation that we see, and just massive number of cases that were brought by state and local governments against the manufacturers of opioids. The public nuisance was the legal theory there. So using some of these, something that was probably a little bit of a sleepy issue in the old case books from years and years gone by, that's the kind of activity that we're seeing with the courts that's particularly problematic.
What state or states do it best in terms of protecting citizens and not destroying companies or raising prices of goods and services? What are the best states, and what are some of the most problematic states?
Well, right now, if you were to take the second part of your question first, we publish a document every year. Our foundation does the Judicial Hellholes Report. We would put, surprisingly, Georgia and Pennsylvania, really the Philadelphia area and the Pennsylvania Supreme Court, as being the most problematic areas in the nation. To give you an example of what we highlight, in Georgia a few years ago, tragically in the aftermath of the death of a couple that were in a Ford truck. They were in an accident. There was a rollover, and the husband and wife tragically were killed in the accident. However, there was the issue that came up in the court on a challenge against what's called the crashworthiness of the vehicle was that the individuals were not properly wearing their seat belts, and the expert evidence indicated that there's a decent chance or a good chance that they would have survived had they used their seat belts properly. But what was interesting, or we think fundamentally a problem, is that information was not provided to the jury in this case, and it had a very long and tortured case. The award was $1.7 billion, and it has survived post-trial motions. It's now being appealed up the chain. Now, if you've been following litigation, one of the things we've learned in recent times is something called an appeal bond. You can't just say, well, there's this big award, and we have to file an appeal. You have to post a bond, and often it can be for that amount or even more. So that's a challenge. But that's an example of the type of litigation problems that we see in some of these jurisdictions. To cite two that I would say on the positive side, going back a number of years, Texas did a terrific job, although we're starting to see some specific areas in the state that are of some concern. But going back to George W. Bush as governor, now we're talking a generation ago, but through current times. And I would say more recently, Florida. What I mentioned earlier with Governor DeSantis and some wonderful legislators, Tom Fabricio and Tommy Gregory in Florida, enacted a great statute. I think improvements in the appellate courts, those would be the two that I would highlight.
I run Americans for Tax Reform. We go to the 50 states and say, if you want people to invest in creating jobs in your state, have lower personal taxes, income taxes, have lower corporate income taxes. And you can see individuals, workers, investors, businesses move out of blue states with high taxes to red states with low taxes. To what extent are people able to move away from bad tort law? The problem is, if you're Ford and somebody has your car and you don't have a factory in Georgia and you don't want to know anybody in Georgia because you think they've got crazy tort laws, can you avoid Georgia tort law, or are you stuck living with, okay, can states solve a problem that helps the state, or is it too much of a national thing because a Texas business could still get sued in Georgia? You see what I'm trying to get at? Because you leave California, you're not paying California taxes. It doesn't matter. Right. You're gone. You're now in Texas or Nevada or Florida. You don't have a personal income tax. And how much of that can be done with tort law and how much can't?
Well, it's a good question. I think that as far as there's no question, if you were to talk to Rick Perry, for example, we've heard him say publicly back when he was governor of Texas, he advertised that, hey, one of the reasons to come to Texas is not just the taxes, it's also the tort system. So there's no question that that's used as an incentive for businesses to locate. Having said that, the basic jurisdictional questions about where a case can and can't be brought, you have to keep in mind that it's the plaintiffs and the plaintiff's lawyer that initiates. So then it's a question of what are the jurisdictional rules. And for the reality is that any auto company is going to be subject to Georgia law and subject to California's law, another jurisdiction that we would put kind of in the perpetual judicial hellhole standing. The question is sort of how balanced is that? Cases should ultimately only be brought, at least in our judgment, where there's some relationship between the parties, and in this case, usually the plaintiff and the underlying act. If you have an auto accident in North Carolina, the case should not be brought in California. It should be brought in North Carolina.
Okay, but if you're suing the company, it's not. It's where the accident was, not where the company built the car?
Well, it's generally, where the accident would have, would have taken place. That's general.
50 states, if you would ask me which ones have good tax laws, I'd say 7 have no income tax, very good. 14 have single rate taxes, pretty good. 24 are cutting taxes. 50 states, how would you rank them on where they are on tort reform and how they're reforming?
Yeah, well, we're going to come out with a look at some of the legislative activity, but I think if you look at our judicial hellholes report, that's a pretty good indicator of, where the problems are. I mentioned, Pennsylvania. I mentioned Georgia, California, New York. There's probably some overlap between the the ones that wouldn't be on your 5-star list. And on our hellholes report, but those would be some that we would be quite concerned about. But we also see a little bit of the kind of a bit of the populist thinking that the courts can be a way to get at sort of large institutions, and our feeling is large, small, red, blue, they all should be treated fairly under our civil justice system.
Okay. But just quickly, 50 states, 20 of them doing much better, 10 of them doing much better.
I think my standards are pretty high, so I would put the number at the top being relatively small, maybe 8 to 10 probably at most.
Okay, and then everybody else is bunched together in bad, or is there a 10 awfuls?
Well, I think we usually have about 10 in our hellholes report, so those would be the ones that we would put at the end. And I think you're going to see some variation too. And then also, candidly, there's some jurisdictions where there's just not a lot of activity, so we don't have a much of a basis to determine whether they're good, bad, or indifferent. So litigation tends to flock to certain places. As I said, the defendants don't get to pick where they're initiated. So,
loser pays. U.S. law versus British law versus other countries. Sometimes that's explained, given as something that if we did that, there'd be less of a problem. Your take. What does loser pays mean, and what do we have in the States?
Yeah, we really don't have it. There are some indicators of what it would look like. I think our antitrust laws. Federal antitrust laws provide for a fee shift so that the losing party, I think the case I always remember is, for those who are old enough like me to remember, when the U.S. Football League was the rival to the NFL, and they sued the NFL in an antitrust case. They won $1. And under the antitrust laws, the award was tripled to $3, but the NFL got to pay the USFL's legal fees. So I think there's my personal view, which is this is not something we've really looked at a great deal, but I think that there are going to be a lot of instances where I think juries would be reluctant to fine for a defendant if it was thinking that the plaintiff was going to have to pay the defendant's fees.
But Britain does loser pays?
They do some, I believe they do some version of it. I was saying to someone yesterday that I was talking to, I haven't kept up with what's all the details in Europe. We've got our hands full here, but that's the origin, and there is a sort of rough justice type of sentiment to it. But I'd be a little concerned about the kind of as applied. Okay, last question, and thank you very much for your time. Third-party litigation funding.
What is that? Why is that in the news? How big a deal?
Well, it's a big deal. I think in terms of sort of the global change in litigation, this is probably the single greatest. The easiest way to explain this is that the traditional notions in civil litigation is that you have two parties and it's their interests. It's A versus B. It might be a person versus a corporation, two corporations, what have you, or multiple parties, but it's their interests that are served. Well, now the simplest way to put it is that litigation is becoming an asset class. It's become something that people can invest in, and taking an economic stake in litigation, providing more capital. We did an estimate that I think this in 2023, over $2.4 billion was spent on advertising for litigation. Well, a lot of the money to pay for those ads comes from these litigation funders, people who invest in the different aspects of litigation, whether it's an individual case or some of what we call the mass tort cases. And so it takes a lot of different forms, but these Burford Capital is the name of one company. It's actually publicly traded, so it's providing a lot of, we were getting some more information on their activity than we do most. Part of the issue that we see with these major financial firms, hedge funds, private equity firms putting money into litigation is that we really don't know what they're doing. There's no as a general rule, no mandatory disclosure. And there's some suggestion that we've seen examples where you've got sovereign wealth funds. So you've got foreign government type entities investing in our litigation. So if I'm a sort of devious type thinking about how can I, create problems for the American economy, well, how about let's turbocharge financially the issue, the litigation system, so there are more lawsuits being brought against major and important American businesses.
Okay, well, Tiger, thank you very much. If you could tell people how they can reach you or get you online or follow you on Twitter to learn more from your organization.
Sure. Well, we got a lot. Thank you, Grover. Thank you for the opportunity. You can find us on probably the best through our website, which is www.atra.org. Probably very similar to yours.
Okay, that's true. Okay, Tiger, thank you very much. Thank you, everybody, for joining us. This has been Leave Us Alone with Grover Norquist. That's me, and with Tiger. So take care, guys. Thank you very much. Take it easy.
Thank you, Grover.